Hello, everybody. On your screen is an outline of the, I'm just trying to work through this. Can we get to the next page of this document? Okay, thank you. I am not going to go item by item on this handout, but this is a good comparison chart of the Reg A Plus, Tier 1, Tier 2 that we are going to be talking about today. The previous webinar on Reg D is there, and you can also see the Michigan Crowdfunding Act. So it's a great chart to compare the various types of offerings. With regards to Regulation A Plus, it was mandated under the Jobs Act to provide small issuers with increased access to the capital markets. It is considered the easiest path for private and small companies to access the capital markets because it allows issuers to raise money and through unaccredited investors. Reg A Plus will greatly facilitate the ability of these companies to access the capital markets. With regards to the securities that are issued as a result of Reg A Plus, they're non-restricted, freely transferable debt and security instruments, including warrants and convertible securities. However, you cannot have asset-backed securities via Reg A Plus. Another important point is that these are not restricted securities under Rule 144, which means that they are freely transferable and may be listed or quoted on various exchanges. That is the current drawback to Regulation A Plus is there's no liquid markets currently exist. However, in the last month or so, many broker-dealers, including clients of mine, have shown interest in starting to list Reg A offerings on various exchanges. So that's going to be a growing area in the very near future. The reason for Reg A Plus, one of the main advantages is it's an attractive and cost-efficient way to raise capital through a public offering. Now, Reg A Plus is also called, quote unquote, a mini IPO, and we'll get into more of that later on in this presentation. Reg A Plus is an attractive way for small and private companies to gauge the appeal of their offering in the general public, and that is called testing the waters. And a couple of the handouts that we provided in this seminar is the LEO motors, and we'll talk about that as well. Under Reg A Plus, there's Tier 1 and Tier 2. If you see it on your chart, there are basically four requirements to each Tier 1 and Tier 2. In regards to Tier 1, you can raise up to $20 million. You can use unaudited financial statements, and you can have unaccredited investors, and the documents that you file do get reviewed by the by the state. And that is one of the biggest comparisons between Reg A Tier 1 and Tier 2 is the review by the state. And we'll talk about that in a moment. In regards to
in fact, Michael, it's probably a good time to talk just a little bit about the overall process. And of course, what we see when companies are trying to raise money is a whole continuum of options. And one of the trickiest things is to find the options that's best for your circumstance. What is your company doing? How much are they looking to raise? And from whom are they looking to raise it? And at one end of the spectrum, you've got the private offering, which might raise a small amount of money, might have some unaccredited investors, but would probably rely mostly on accredited investors, and it's going to have to find an exemption both at the federal level and at the state level. For everything that we do, when it comes to any offering of any security, you have to make sure that you either have it registered or exempted at both the federal level and the state level. And sometimes people miss that. They think that, well, if we do Reg A at the federal level, we don't have to worry about the state. Or if we file a score form at the state level, we don't have to worry about a federal exemption. And that's absolutely not true. Now, you can register at the federal level and get an exemption at the state level. Or you can register at the state level and get an exemption at the federal level. Or you can register at both or be exempt at both. So there's a lot of combinations. But you have to make sure that for every security offering, your company has established which exemption or registration process it's using at the federal level and at the state level. And so that's one of the points that Michael's making. Reg A Plus is sometimes called the mini IPO because it kind of stands right in the middle between the private offering and the registered public offering. So it's got some aspects that are very much like a private offering, but it's got some aspects that are kind of like a public offering. But technically, Reg A Plus is an exemption from registration at the federal level, which means particularly for the Tier 1 items that Michael was just talking about, you must make sure that you get that exemption or registration for your offering at the state level as well. It's not enough to just comply with the federal exemption of Reg A Plus. You also have to find either a registration or an exemption if you are Tier 1. Michael?
Okay, and we'll stick with the Tier 1. As I said, as I previously said, that you can raise up to $20 million on a Tier 1. You do not need audited financials. A restriction is that you only can sell off approximately $6 million or 30% of the offering in any 12-month period. That is something that needs to be worked out a little bit more, but it's really not topical, or it's moot right now because it's just not being done just yet. And the fourth requirement, which is probably the most important, is that although the offering is exempt, the state has carved out a review process. You have to register documentation with the state, and they review it. Now, what Jim and I and Linda Cena, who was the opening speaker for the state, we had a conference call with the State of Washington Security Division, and they talked about a coordinated review program that I'll let Jim talk about right now.
The coordinated review program is a very nice way that the federal government and most of the state governments have addressed this need for having exemptions and review at both the federal level and the state level when it comes to Reg A+. For most offerings, you're completely on your own. If you want to do a Reg D 506 offering, you've got to make sure that you've got the exemption secured at the federal level, and then you also have to make sure that you either register or you are exempt in each of the states that you want to have any activities in. One of the tricky things with the securities law is that any offer of the security brings you into the need for registration or exemption. It's not that you have to sell the security before you have to worry about the SEC and the state securities regulators. It's as soon as you make an offer. An offer is very, very broadly defined. And so in some of the materials that we've given you today, and we may put them up on the screen a little bit later, but just to reference them, you've got a number of helpful state exemptions and why you need them. And in that section that I drafted, if you take a look at Article 7, Roman numeral 7, there's some very helpful combinations of state exemptions or registrations coupled with federal exemptions or registrations. But getting back to this fairly new idea in Reg A+, the statutes that put this into place gave the opportunity for this coordinated review that 48 states have signed up on. So if you want to sell in New York or Arizona, they are not part of the coordinated review program. But the other 48 states in the United States are, and it's handled by the state of Washington. And so what you're able to do is file your documentation, the Form 1A that you'd be preparing at the federal level. You use that same form and you file it with the state of Washington and indicate to them which states you want to do securities offerings and sales in. And so if you're doing it in more than one state, the coordinated program is very nice because you only have to provide the paperwork to one entity. And within 21 business days, the state of Washington will send that information out to all of the states that you choose, anything from 2 to 48, and then get you the coordinated comments back on what you might need to consider and changes that may need to be made in order to go forward in the states that you've chosen. The only downside to the coordinated system as I see it right now is the fact that there is no financial coordination, which is to say most states have some sort of fee for going through this process, and that fee has to be paid by the company individually, state by state. So if you want to do the offering in 20 states, you would have to pay that fee, and whatever the fee is for each of those states, and the state of Washington has very nice documentation as far as what the fee is and who you need to send it to. But the company is still responsible for sending that out to each one, and some of the states will not start the review process until they get paid that fee. So it can be a real delay if you forget to do it, and that can take you outside of the 21-day window. But if you are paying those fees at the same time you're making that filing, the state of Washington has been very committed, and the states have been working very well together so that you can get review in 48 states in 21 business days, which, if you've ever worked in securities offerings before, is a relatively short period of time. Some would say a very short period of time. And so that helps to ameliorate some of the difficulties of getting the state piece of the exemption in place. Because the states are also different in the approach they take. Some states have a substantive review, where they will actually look at the quality of the security and decide whether it's an appropriate type of security and type of offering for their state. Other states are strictly information-based, where all they do is they make sure that the disclosure that you've provided meets all of the requirements. Whether the security is a good investment, a bad investment, a wonderful thing for some people, or a terrible thing for others, these disclosure states don't worry themselves with. They only look at the type of disclosure that you've made, where other states will look at the substantive type of security that you're actually offering. So keep in mind that the state of Washington, if you're going to do a Reg A Plus, is a very nice way of handling that in multiple jurisdictions. And these days with communications the way they are, it's awfully tough to imagine that a offering of any size is going to stay in any one state. It seems like it could very easily spill over into at least a half dozen or more. And there have been some state compacts before where multiple states will get together and have some coordinated review. But this review for Reg A Plus offerings handled by the state of Washington and applying to 48 different states is much broader and from everything I've seen so far, much more comprehensive than anything we've seen in the past.
Okay, we will switch now to Reg A Plus Tier 2. And you can look on your charts there and see that in comparison to Tier 1, you can raise up to $50 million in Tier 2 as compared to $20 million. The second requirement is that the financials in a Tier 2 must be audited. However, the audit firm does not need to be registered with the Public Company Accounting Oversight Board, as would if you were doing a full-blown IPO. Again, the difference between a Tier 1 and Tier 2 is audited versus unaudited financials. This allowance of an audit firm not being registered with the PCAOB gives greater flexibility to the issuer. It enables them, quite frankly, to save a substantial amount of money with regards to preparing and presenting the financials for their offering. Comparing in a Tier 2, the insiders can sell up to $15 million in a 12-month period as compared to $6 million of a Tier 1. And finally, the most significant change or difference between Tier 1 and Tier 2 is in Tier 2, there is the preemption of state blue sky law, which means once you do your filing with the SEC and you do not have to file or qualify your offering through the state government. And so what Jim was just talking about, the coordinated approach, is not applicable to a Tier 2 offering. And that is probably the most significant practical difference between Tier 1 and Tier 2 is the approach to state regulation or qualification. From a practical point of view, this difference results in many issuers that are thinking about doing a Tier 1 basically deciding to do a Tier 2 so they can avoid the state regulators. However, with the advent of the coordinated approach, that worry might go away. And so that is the practical point of view. Now, let's turn our attention over to testing the waters.
Although, Michael, we still, one quick point on the states, though. Even in the Tier 2, even though there's not any review by the state, they can't make any comments, they're not going to indicate that the disclosure is lacking or that there's a substantive problem, you still have to keep in mind that the states are entitled to filing notice. And so you still have to let the states where you're going to be doing activities, offering and selling those securities, or I should say offering or selling those securities in those states, you still have to do a filing with the state to let them know and to pay the state fee. So the states are not cut out of it entirely, but Michael's point is a good one. The Tier 2 gets rid of that, gets rid of the situation where you have to actually wait for the state to get back to you and let you know what they think about your offering and actually approve the offering. So getting rid of that step can be very valuable, although basically it comes down to, would you rather have audited financials or would you rather have review by the states? As Michael mentioned with the coordinated program, as long as you're not looking at being in New York or Arizona, you might find that the Tier 1 is more attractive from the internal standpoint, that going through the states might be easier than dealing with your accountants. I guess that's more of a personal question of how good your accountants are. Seems like securities lawyers and accountants are always at each other's throats for one reason or another. So I might like the Tier 1 better. I'll take the state regulators over most accountants. But it could be a real advantage to not having to do anything other than the notice filing and the paying of the fee.
Okay, we'll now talk about testing the waters, and this is absolutely a huge new benefit. It's new in the securities industry. You could never advertise or solicit investors before the Jobs Act, both under, and if you look at the chart, Reg D Rule 506C allows for testing the waters, but it's Reg 8 plus, both Tier 1 and Tier 2, that are substantial, benefits is testing the waters. And this allows a small company to test the waters to see the interest in their offering by the general public. General solicitation includes solicitation to unaccredited investors. You can solicit on Twitter, on all type, television, billboards. Every type of solicitation / advertising is now allowed. and that was never allowed before. And this way, you can determine whether there is a market for your offering. We will turn our attention over to Elio Motors, and Jim, if you can figure out how to pull that up on the screen. While he's doing that, I'll give you a little bit of background on Elio Motors. They were looking to raise about $3 to $6 million. They filed the document that you have in your materials that you were emailed yesterday. And if we can go to page 2 of that document. Okay. Hold on 1 second. Sorry. Okay. With regards to testing the waters, Elio Motors wanted to raise $3 to $6 million, and they ended up getting $17 million in commitment. They hit a grand slam. So Elio Motors is like the poster child, for solicitation. Now, on this page that we have in front of us, the second line, if you look at it, it says information contained in this preliminary offering circular is subject to completion or amendment. Okay? Now, what that means is that the financials can change, the offering terms can change, but any company is allowed to send this to the Securities and Exchange Commission and ask them to qualify their offering. Now, Jim, can you pull up the SEC reply to Elio Motors?
There we go.
Great. And if we could go to page 4. Okay, item 19. And if we scroll down, the second paragraph is, we will consider this is a letter from the SEC to Elio Motors after they submitted the previous testing the water document. And their response was, we will consider qualifying your offering at your request. And then they always have, if a participant in the offering is required to clear compensation agreements with FINRA. Now, FINRA, for those of you that don't know, is the self-regulatory agency that regulates security broker-dealers, stockbrokers, and the like. And so if you are in some way required to disclose your compensation, that's what the SEC is trying to state there. But then we go further down in that paragraph. In the event you ask us to qualify your offering statement, please provide a written statement from the company acknowledging the following. This never occurred before. What did occur previously is companies, if they had a question about a potential offering, they would ask for no action letters. And you can go to the SEC's website and find numerous no action letters. And a lot of times when I previously did offerings for clients, we would go to the no action letters and find something on point, find a letter or the type of offering on point, and utilize the statement contained in the no action letter as a guide to our offerings. These two are just unbelievable, this whole testing the waters area. Now, we'll go on with regards to what are the critical requirements of, you can go back to the original chart if you can, Jim. The critical requirements for Reg A Plus are that the company must be incorporated in the United States. The cost, people always, well, what is the cost? Now, previously, we were told that the cost would be approximately $30,000 to $80,000. Jim brought up at the live conference on this topic last week that you could pay up to $250,000 for to go to an IPO. And Jim, if you could bring back the the story you had about Google and their IPO.
Oh, absolutely. A couple of points. Inc. magazine had opined that companies that go public can expect to pay more than $2 million in out-of-pocket expenses to cover a whole host of fees, among them legal, accounting, printing, listing, and filing. That does not include the cost of selling the securities, the brokerage commission if you're using licensed broker-dealers. They can expect to pay about 7% of the offering price in sales fees, commissions, and then, of course, can also expect to show up their internal processes. So going public can be a relatively expensive affair, which is to say you need to make sure you're raising enough money so that those upfront costs are a fairly small percentage of the overall offering. Spending $2 million plus 7% of the offering in order to raise $4 million is probably not a very effective route to take. We also see that the definition historically of offering was very broad. And when Google did their initial public offering, their CEO did an interview with Playboy magazine and mentioned that Google is doing great, we have lots of satisfied shareholders, and we're looking at the possibility of going public later this year so that even more people can enjoy the benefits of ownership in Google. That's basically, I'm paraphrasing, but that's basically all he said. And the SEC considered that a general solicitation of offering of securities, and they delayed the Google IPO by over 8 months, which caused Google to incur additional several $1 million in costs in order to work its way through the SEC following that violation. So being able to test the waters, being able to communicate with investors by having a document that's qualified that can still be changed, that can still be altered based on the responses that you get, is a relatively new and very exciting aspect of Reg A+.
Thank you. Excuse me. The documentation that a small company or an issuer needs to properly file a Reg A+ offering includes the corporate records, articles of incorporation or organization, bylaws, corporate resolutions, corporate minutes, shareholder records, shareholder agreements, if there's any litigation with the company, material agreements, material contracts, contracts with customers, contracts with suppliers, contracts with manufacturers. So you can see that there is a requirement to have considerable information about the company for these offerings. However, even small companies that don't have that many material agreements, the work or the documentation and disclosure is not that burdensome because a corporation has these kinds of documents at their fingertips in their corporate records anyway. So it's not that difficult to put together the documentation for a filing. Now, what are the advantages of doing a Reg A+ as compared to a Regulation D 506 offering? Now, if you look at the chart, you can see that in the middle of the chart, the Reg D 506A, B, and C, and as compared to the Reg A. Now, the advantages of the Reg A are that the securities in a Reg A offering are not restricted. In a 506, the offerings are restricted, which means they're not freely transferable. As I said earlier, you can sell the Reg A plus securities on an exchange, and we're seeing more and more of that as we go along. Reg A plus securities can be offered to the general public, as we talked about solicitation. Only Reg D Rule 506C allows general solicitation. And Reg D Rule 506C is, again, another new rule as a direct result of the Jobs Act. Sales to Reg A Plus allow sales to non-accredited investors. And again, under the Reg D, you can't except under Rule 506C. In a Reg A Plus, you can rely on purchaser self-certification, which means the difference between a non-accredited investor and an accredited investor, where in a 506, Rule 506 offering, the issuer must take substantial steps, reasonable steps to verify that an investor is accredited. Now, we won't go into it, but in a Reg D offering, you're allowed up to 35 non-accredited. Well, that's important because if you're doing general solicitation on the internet, Twitter, websites, whatever, you know, and you're doing a Rule 506, you got to be very cognizant of who's accredited and who's not. And a Reg A Plus allows you more breathing room with regards to the self-certification.
It certainly does, Michael, because what we see, of course, in the general population is that only 1 to 2% of the general population would be able to qualify as an accredited investor at any given time. And even though you can do general solicitation for a Reg D 506C offering, which, as Michael said, is new, you still run into the problem of having to do this substantially enhanced due diligence in order to make sure that if you're counting someone as an accredited investor, they really are one. Historically, people would use a check-the-box approach. Check this box if you're an accredited investor. And it was amazing how many people would check that box so that they could make the investment, and it turned out to be a dirty lie. And so the concern that the Congress put in place was that we needed some additional information. And that enhanced due diligence is going to include things like either getting tax returns in order to establish how much income somebody has, getting bank statements or brokerage statements in order to establish how much assets an investor has, or getting some sort of certification from that person's attorney or accountant. And in most cases, we find that it's that certification from an attorney or accountant. Most people are pretty uncomfortable giving up their tax returns or their brokerage and bank statements. So normally in that sort of case, you'll find people will go to their accountant or their lawyer to get some certification, but that can still be a burdensome and time-consuming process. Because of the other protections that are put in place as part of Reg A Plus and the desire in order to permit kind of these mini IPOs, right, as we get closer and closer to registration, as more and more information is provided, as more and more review is done, we get more comfortable that the bad eggs are going to get sifted out before investors start to make investments. So Reg A Plus simply says if you're counting the accredited investors, you can continue to rely on their self-certification for Tier 2. And in fact, we're so not worried about it for Tier 1 that there is no investor requirement at all.
Let's take a look at what are the advantages of a Reg A Plus versus a traditional IPO. As we stated earlier, a Reg A Plus offering is considerably less expensive and a lot faster to get through and get to market. A Reg A Plus has the documentation that we talked about earlier is less expensive than an IPO. Just the mere fact that the financials not only do they have to be audited, but they also have to have their auditing firm able to perform that audit. And let's talk about the ongoing reporting requirements. In a publicly traded company, you have to file quarterly reports, annual reports. If there's a material change in operations, you change accountants, you sign a large contract, you fire or hire a CFO, CEOs, you have to file, 8Ks. You have to file all kinds of ongoing requirements for an IPO, where in a Reg A Plus, you have a minimum of filing requirements ongoing under Tier 1, but there's no ongoing requirements for Tier 2. Interesting, the reporting, the ongoing...
Oh, Michael, sorry, you got that backward. For Tier 1, there's no ongoing reporting requirements for the lower dollar value. For Tier 2, there are some reporting requirements, but as Michael said, and it's an excellent point, the ongoing requirements of a Tier 2 offering under Reg A Plus are much, much less than the public company disclosure that you have to make when you're a publicly traded reporting company.
That's correct. Sorry about that. And the reporting requirement stops under the Reg A once the offering is completed. And that's a very important point because there's no ongoing reporting requirement. And that's extremely huge with regards to that. The difference, the advantage of an IPO over a Reg A Plus is you can raise over $50 million in a traditional IPO where you only can raise $50 million in a Reg A Plus. And most small companies don't need to be going over the $50 million mark. The Reg A Plus, I'm going to wrap this part up and then Jim can talk about the other exemptions. The Reg A Plus will develop into another, it is an intermediate step in raising capital for startups, growth companies, emerging companies, all the way to full-fledged reporting companies can offer Reg A Plus types of securities. So it's a great opportunity, it's a great advantage to be able to go to the market, to the potential investors, and say, we would like to raise X amount of dollars for our company, and here's how we propose to pay it back, or here's our business plan, and see what the temperature is out there for your money raised. Jim?
Thank you, Michael. And so you can see that there's a number of different ways of raising capital, and we talked a lot, and the focus of today, of course, was Reg A Plus, the advantages, the disadvantages, where it fits in. Reg A Plus is obviously brand new, came about because of the Jobs Act. This idea of a Reg D Rule 506C offering, also greatly enhanced because of recent laws. We've also included some materials on some of the old and boring approaches to raising money. Because for some of you, the idea of raising $17 million, $35 million, your company might not be there yet. You may be looking at smaller amounts. And in that case, the private offerings can still be very valuable for you, keeping in mind that you still need a federal exemption and a state exemption. And so the materials here, helpful state exemptions and why you need them, just basically walk through those items. And as I mentioned before, the first pages all just go into kind of background. They talk about the registration process. They talk about various federal exemptions from registration. We talk about Michigan registration. So if you're a Michigan company, what can you do in order to register? And the SCORE registration process is a very simplified version. Again, still much easier, much less expensive than even the Form 1A or A1. I hate it when the dyslexia kicks in. But the form that is used for the Reg A Plus, Form 1A, the SCORE U7 is a much more scaled down item that almost is kind of a question and answer. You just kind of fill in the blanks on the form and you're off and running. And once you get through these materials, then you get to some combinations that are useful. And so the real guts of this part of the materials is to get you to Part 7. If you read something in Section 7 here that doesn't make sense, go to the earlier sections and it will clue you in. But if you're looking to raise up to $1 million in a 12-month period, you want to advertise to the public, combining Federal Rule 504 as an exemption at the federal level and a SCORE filing for Michigan registration can be very effective. And relatively inexpensive. So you can easily raise that money and still comply with the state and the federal laws. If you want to stay exempt, you don't want to go with the score filing, the Rule 504 and Michigan Section 202 1N is very nice. You can raise up to $1 million in a 12-month period, up to 50 purchasers. Disclosure document of some type is required, but you've got a lot of flexibility on what it is. And there are no filing fees, either at Michigan or at the federal level. So again, a nice way of doing that. And then there have been a number of comments from nonprofit entities, school booster clubs, maybe a church, or some other type of community-based foundation that need to raise some money in order to accomplish something, and they're going to do it by borrowing. And if you want to borrow up to $500,000 in a 12-month period, you can do that through community investors by combining Federal Rule 504 and Michigan exemption in Section 201G. And that is a self-executing exemption. There's no Michigan filing or fees that need to be done. You do have to file the federal Form D, but again, there's no fees there. So when you're working through these items, you do want to make sure that you're conscious of how are we being exempt at the federal level, how are we being exempt at the state level. And if we go back to Reg A for just a moment, that question is answered by, if you do the Reg A plus filing on Form 1A, that gets you your federal exemption. And then if you're a Tier 1, you would go through the coordinated review process with the state of Washington for the various state exemptions. Or if you're Tier 2, then all you would have to do is the notice filings and the payment of fees. So again, you always want to be conscious of how am I qualifying at the state level, how am I qualifying at the federal level. And as long as you're thinking about those two things and you can answer those questions, then the steps that you take and how you advertise fall into place very nicely. Linda, I know that we wanted to leave some time for questions, so have we gotten some questions? Should we turn our attention to that?
We haven't gotten any questions at the moment. I will tell you that was a very, very thorough and clear presentation. I would be surprised if we get many questions. I think you answered just about every question I can anticipate that we would get.
Well, we covered a lot of ground, and I think we moved kind of quickly. So I don't know if there's anything else that people want us to focus in on or go over. The materials that you've got are quite substantial. And as Michael said, the ELIO testing the waters was amazingly successful. They had hoped to maybe get interest in the $3 million range. And they ended up having interest in $17 million. And Michael, I don't know, I haven't heard how much they actually raised. Have they completed that offering?
Yes, they have, and they did raise about 17. I think they ended up with about 15.875, but you know it's still available. They still hit a grand slam.
Oh yeah, they originally looked at $3 million, and then they did an offering where they wanted to get between $12 million and $25 million. So even if they didn't raise a cent more, that still is a grand slam, absolutely. But it shows the ability to adjust the offering under Reg A Plus in order to take advantage of the situation. Also, it would have been fairly nice if they did, well, not fairly nice, but the other side of that coin is, what if you are hoping for $5 million and you test the waters and it turns out that there's only $600,000 or $700,000 worth of interest? Well, you can kill the offering before you incur a whole lot of the expenses if you're able to test the waters and test them effectively. So even on the downside, there is the potential for avoiding kind of the strikeout or hitting the grand slam or anything in between.
And that's where literally the page that you have up, your Section 7, page 4 of 5, shows there's alternatives. You know, if you only have $600,000 or $800,000 in interest, you know, you can use Rule 504 with Michigan Section 202A, you know, item number B on that page. So it's not getting the interest you want sometimes helps and clarifies your offering, or, you know, what's happened with some of my clients is we go back to the drawing board and say, what didn't people like about it? Is it your pro forma? Is it the payback? You know, why don't people want to invest in this? And of course, you know, if it's a down market, it's a down market, but there's always people willing to invest in alternative investments or exempt offerings, and that's what that, you know, this Section 7 is beautiful to show, you know, different alternatives to Reg A+.
And of course, those are just a few of the alternatives. When you start looking at 504 versus 505 versus 506, when you take a look at the mile exemptions, when you take a look at the Reg A+, when you take a look at the various state exemptions, the score, registration, there are a lot of combinations and permutations. And so being aware of that whole continuum can be very valuable, because if you do test the waters in a Reg A+ situation and it does turn out to be less than you hoped for, then it is a question of finding the right box. Let's go to the right type of offering so that our expenses and commitment to disclosure line up with the amount that we're actually raising. And so being able to do that, I think, can be very effective so that the costs of getting that capital don't outweigh the advantages. And so being aware of the various options that you have can help you adjust if, like Michael says, you have to go back to the drawing board. And that happens sometimes. The other thing to keep in mind is everything we've been talking about today and the vast majority of these exemptions and private registration regimes deal in the amount you raise in a 12-month period. So if you raise a little bit of capital through a combination of federal and state exemptions, you raise $900,000 in 1 year, then 13 months, 15 months.
Okay,
Jim just went silent. I'll pick it up. How's that? Can you hear me?
Yeah, but there's a noise. Oh, now the noise is gone. We're all set. Now we
No,
can.
I'm not. Mine isn't working either.
Okay, well then I guess at this point, since we had gone through everything, we'll go ahead and do a wrap-up.
Okay.
Because it sounds like for some reason both of our speakers are unable to speak. I guess I'll thank you all for joining the second of our 6 Lunch and Learn webinars. We hope you enjoyed it. We want to thank Jim Carey and Michael Marsalese for taking time out of their busy schedules to share some very important information with us. I want to remind everyone that a recorded version of this webinar will be available for viewing at www.michigan.gov/securities in approximately 2 weeks. Our next webinar is scheduled for April 13th and will feature Jeffrey Labine of Miller Canfield, and he'll be covering legal and structural basics, key formation, and often overlooked issues. If you've ever, for example, wondered how should I start my new company, should it be an S Corp or a C Corp, how can I protect my ideas, our next webinar will answer all of those questions and more. And one last reminder that our next upcoming live seminar will be in Grand Rapids on May 17th if you would like to sign up. The seminar is free and breakfast and lunch is included. Once again, thank you so much to James and Michael for presenting, and thank you to all of you for coming, and have a nice day.
Thank you. Thank you.